Welcome back to The Mind of Money. My name is Douglas Lodmell, and I'm back with my guest, Howard Rosen. Howard, we were just talking about the Asset Protection Trust, the core of the plan, the cornerstone of the plan, and during the break you mentioned a couple of other things about it.
I just wanted to highlight the fact, I mentioned that it is the core of the client's estate planning, and in that sense it includes, typically for a married couple with children, it will include provisions for the children, and the trust can actually go on for the grandchildren and great-grandchildren.
Continue to protect the asset.
Forever.
Yeah.
From whatever occurs in the children's lives or the grandchildren's lives. You just never know. So, I mean, it can be structured that way.
Now, updating and managing that as opposed to your revocable living trust where you have all the positions,
okay.
Are there some more technicalities or a few more steps that you have to go through?
Yes, because the trust is irrevocable, which a conventional estate planning attorney would take it as meaning it can never be changed.
Right.
But you and I know that irrevocable is just a word, and it means that the settlor can't revoke the trust, but the trust, the way we structure it, can be amended by the trustees with the consent of an independent party called the trust protector.
Right.
Okay, the way we do things, we have an independent company act as protector. Mm-hmm. The protector of the trust, this is a sort of a feature of offshore trust.
Right.
Okay.
Right. Although I see they're using it now in the conventional.
There's no reason not to.
Yeah, this protector role, they've kind of picked it up from us in the offshore world and brought it in.
I think it's perfectly appropriate.
Yeah.
But the way we structure things in the offshore world is the protector oversees what the trustee does.
Right.
And typically, the protector's written consent is required for any discretionary action the trustee wants to take.
Right.
This makes the clients feel comfortable.
Yeah.
Okay, because there's a third party, an independent company, looking at what the trustee is doing.
Right, right. And I get this question all of the time. How do I know my money is safe? And I actually wrote an article called The Checks and Balances that really explain how these roles check and balance each other. In my opinion, I'm more comfortable with my money sitting in Switzerland in a trust where I don't even have control than I am sitting in Bank of America.
I agree 100%. And we added a feature in our trust because just obtaining the written consent of the protector really doesn't get down to the account level in the trust. Mm-hmm. So, again, the protector has this veto power over any discretionary action the trustee wants to take. So in our trust, we provide that if it is thought to be necessary, the protector can require that when the trustee sets up that account in Switzerland, at the account level, the protector company's signature is required together with the trustee company's signature to get funds out of the account. So you have two independent companies who each use two employees in order to sign to get money out of the trust. And that always makes the clients feel comfortable, particularly since the protector is located in one country and the trustee is located in another country. They don't know each other.
Right. Right. So, and by the way, the bank knows who the beneficial owner is, the beneficiary.
Yes.
That's not a secret to the bank.
Right. It's not a secret to the bank. Right.
You know, it's not like they only know this trust company and this protector company. They know the client.
Right. So in the Swiss account, in a typical Cook Islands trust, you have the trustee looking at the account. You have the protector looking at the account.
Trustee.
Right. You have looking at the trustee, looking at the account.
Yeah.
You have the investment manager looking at the account.
Right.
You have the bank looking at the account. You have more eyes on that account than you would ever have in a situation in the United States.
Right, right. And, you know, if we could spend a minute on the banking system itself, I think that's critical.
I agree.
Today more than ever. I mean, we're talking about Swiss banks that are not leveraged. They are not making subprime loans to...
They don't make loans.
They don't make loans.
They earn their income from charging fees.
Right.
Okay. And typically they use a segregated account structure. People ask me, well, do they have FDIC insurance? They don't need it. They have a much better system.
Way better. And way better than bankrupt FDIC.
Right. They've been in business in the banking business for 600 years.
Yeah.
Typically, if you open up an account in a Swiss bank in a currency other than Swiss francs, the account is off the books of the bank. Let me make an example. If you deposit $100 at Wells Fargo Bank, that becomes an asset of the bank and a liability of the bank to pay it back to you. So you're a creditor of the bank.
Yeah, that's the key distinction.
Right. If you deposit that same $100 in a Swiss bank, It's held off the books of the bank. It does not become part of the financial condition of the bank. If that Swiss bank were ever to go under, the Swiss government would step in and assign the entire account, every penny, to another Swiss bank.
Right.
So,
of which then you would have access to
right,
immediately. Yeah.
Exactly. So it's a much better system than what we have.
Well, it's much better, and today, I mean, it's becoming apparent that this is a real concern. I have clients calling, and they're calling now for nothing else but I want to set up a Swiss account. And I understand that I shouldn't be doing that in my own name. And I agree with that statement as well. Even if it's not asset protection as your motivation, even if it's just changing your banking jurisdiction, you still want to use an asset protection trust.
Sure. Yeah, I agree 100%. And one other point to make about the Swiss banking situation is that the bank can hold U.S. securities, and they can execute trades in U.S. securities or foreign securities. Your trust can directly invest in foreign securities markets as opposed to buying American depository receipts.
Right.
A much more efficient way of investing in the foreign securities market, if that's what you want.
It's a great point, and it's a huge point now because, first of all, just having a global perspective on your investments is now critical. I mean, if anybody's not paying attention to the world right now, wake up.
Yes,
I agree. And I would rather be buying Petrobras on the Bovista in Brazil and not through an ETF or an ADR on the New York Stock Exchange.
It's much more efficient to buy it directly.
Right, and you're right. The Swiss platform is the ideal place for that. So, okay, well, that's great. And I think this particular part of the conversation, if people can get this, it's a huge point, and it's becoming a driver for motivating action.
We have clients that, like you said, they want to, for example, they might want to buy gold from the Perth Mint in Australia, and they want to do it through an offshore trust, and the protection is secondary.
Right.
Okay.
Exactly.
It's just a more appropriate way to do it.
Yeah, exactly. So, okay, good. Let's go to real estate.
Okay.
Real estate is interesting because everything we've been talking about with the Asset Protection Trust works best with something that can be held in a Swiss account.
Right.
I mean, you and I both know and we love when we see a client that it's just all liquid, it's all cash, and the easiest thing to do is go to Switzerland. Some of the clients walk in and that's not where they hold their assets. They hold them in real estate.
Right. We have to play the hand we're dealt, so
that's right.
Okay. At one end of the spectrum, as you mentioned, is cash and publicly traded securities, which are very easy to effectively bulletproof protect.
Right.
Real estate and other immovable assets, such as interest in LLCs, interest in partnerships,
which often hold other real estate. Private corporations.
Those are more difficult to protect, but not impossible. The way those types of assets can be effectively protected is by making them not worth going after for a creditor. How do you make an asset not worth going after? You remove its value.
Right.
Okay. If it's not worth anything, it's not worth going after.
Yeah.
The way we remove the value is by encumbering the asset. We have available to our clients offshore lenders which will loan them a large percentage of the value of the equity in the asset on an interest-only basis. Okay. Take back an appropriate lien. If it's real estate, it'll be a mortgage or a deed of trust, depending on what state the real estate is in, encumbering that property. If it's personal property like equipment or interest in LLCs or partnerships, it'll be a UCC1, will represent the security interest. The loan proceeds then are transferred to the client's trust, where they're protected with the other liquid assets, and the loan proceeds are typically invested in a certificate of deposit, which earns interest, which significantly offsets the cost of the loan, which is an interest-only loan. On the U.S. side of the picture, I'll make an example. Suppose you came to me, you had $1 million piece of real estate with $1 million in equity. The lender might loan you $950,000 against that property. Now, a creditor of yours, looking at the public records, would see, yes, Doug has this $1 million piece of property, but the next thing that's recorded is a $950,000 mortgage, leaving just a tiny amount of equity. Can't be worth their trouble.
Is that really worth going after?
Right.
Yeah.
Okay. It has to be discouraging.
And now, a lot of clients call me and they go, hey, I heard that exact philosophy why don't I just give my brother or my cousin a friendly lien? They'll put this mortgage on it, and it's not real, but it'll have the same effect.
Well, because those transactions will be looked at under a microscope in the event of a lawsuit or judgment.
Exactly.
So it has to stand that test, and the loan we're talking about is from an unrelated lender.
And it's a real bank.
And it's a real lender, yeah.
Real lender,
Yeah, exactly.
So and just to make the point, it could also be Bank of America.
Yeah,
they'll give you $950,000 on $1 million.
They'll make this is just for this strategy is available for the convenience of our clients. Certainly they can go to their local bank,
right.
But typically they'll find that the local bank won't loan them 95%.
Not today.
Okay, not today, and won't do it on an interest-only basis. You want to keep that principal balance of that lien up there.
Up there, yeah. Sure.
And our lenders are somewhat flexible. If God willing, the property values increase someday, we hope that'll happen again. If that happens, we can have the loan modified to take into account the additional equity.
Right, exactly. So
okay.
and this is, I agree 100%. This is the strategy. When you have an asset that we just can't move, we can't physically pick up that piece of property.
We haven't figured out how to move real estate yet.
No, it does just not yet. So just make it unattractive, and we're constantly reminding our clients the key to asset protection is about creating a situation where you hold more cards and you change the balance of power.
That's exactly right. You more than level the playing field.
More than level
it in your favor.
Yeah, I like that.
That's the whole idea.
I like that. So, okay, great. Well, when we come back, we'll pick it up and talk some more about this, and we'll be right back with The Mind of Money with Howard Rosen.
Thank you.